Every day in the USA, people find themselves in court.
Court calls case of the people versus Kirston Heron.
On behalf of the people.
Assistant Public Defender Natalie Pate for Ms. Heron, who stands to my right. Please state your name for the record, ma'am.
Kirston Heron.
Thank you, Your Honor. As to the PCC, this is going to be a waiver, and I would also like to address bond when appropriate. Ms. Heron is signing her preliminary exam waiver form at this time.
Ma'am, it's correct. You want to waive your right to have a preliminary examination. You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 4 with 5 following.
Thank you, Your Honor. We acknowledge receipt of the information, waive any further reading, and ask that my client stand mute.
Defendant having waived former reading standing mute. Court will enter a not guilty plea. Pre-trial will be set for
June 3rd at 1:30 before Judge Slay Monday.
June 3rd, 2024, 1:30 Slay Monday. As to bond, briefly.
Thank you, Your Honor. As Your Honor is aware, Ms. Heron was last in front of you last week for probable cause conference, at which time she was remanded for her bond violation. The underlying bond violation was that she had picked up a new charge out of Ohio. She has served 7 days on that bond violation, and we are respectfully requesting that you consider releasing her again today on the previous bond with the previously imposed bond conditions, including the GPS track and tether. Prior to this bond violation
But the violation that you picked up in Ohio was the same type of behavior that we have here, which was assaulted.
It is correct that it's a similar charge, yes. Outside of that bond violation, she has otherwise been compliant on bond understanding. Ms. Heron presents as a 20-year-old woman with no prior adult convictions. She lives in Toledo with her mother. She was prior on that GPS tracking tether with no bond violations outside of the new charge. She has a strong support system, including her mother and sister, who I've also been in contact with, and I believe they're in attendance here today. They were in attendance at her last court hearing, as well as her 3-year-old niece. Ms. Heron regularly cares for her 2 nieces, ages 3 and 5, has their support, as well as her sister and her mother. She did hold down a job at Nordstrom for about 6 months and recently has been looking to break back into the retail world and is job seeking. Outside of the Ohio arrest, she has no other bond violations. And as to the Ohio arrest, she was released from Ohio custody on Monday, May 6th. While she was in Ohio custody, they, of course, cut off her GPS tracking tether that she had to Warren County. That next day, Ms. Heron contacted the public defender's office, and they advised her to drive up from Toledo immediately to go to community corrections to get her replaced, which is what she did. She returned back on Wednesday, May 8th, and got her GPS tether off installed again and appeared again in person for her probable cause conference on the 9th. Ms. Heron takes this case extremely seriously. She takes her obligations to the court very seriously, and she's asking that the court, for the prior bond violation, sentence her to 7 days, credit 7 served, and release her today, reinstate her bond back on a GPS tracking tether.
Any response from the people?
Our concerns, I assume are echoed by the court. The underlying facts of this case are basically an assault, neighbor dispute situation in Pittsfield. And as I relayed when this was up a week ago, there are comments in the Pittsfield Township Police report about prior contacts with this defendant and her aggressiveness towards the police. Given her age and the fact that this again happened while she was out on bond, I just have concerns whether we're dealing with a mental health situation, behavioral issue situation. I don't necessarily think that the defendant needs to remain in custody, but my concern is what plan is in place when she's out of custody. Obviously, she was on a tether and that didn't stop her from reoffending.
Well, it didn't stop her from reoffending, and my understanding is it was another, she came into contact with police officers and you got the same scenario here. You got additional assaultive behavior.
And they remain pending charges and allegation at this time, Your Honor, but the allegations are similar. I do acknowledge that. But I also, Ms. Heron does take this very seriously and has been very active in participating in her defense. And we ask that she be allowed to be out of custody on her previous PR bond in order to continue dealing with these allegations.
You can bring that up with Judge Slay. Motion for bond reduction denied. Bond will continue. Thank you.
Your Honor.
Court calls the case People versus Bruce Jones.
Attorney Morgan Rose on behalf of the people.
Assistant Public Defender Odetella on behalf of Mr. Jones this morning, Your Honor, who stands to my right.
What are we doing?
I do believe that there is a bond violation that needs to be addressed, as well as I need to address the defendant's phone privileges.
Yes, Your Honor, that is our understanding. Go ahead, Mr. Rosa.
Your Honor, are you in receipt of?
I have the police report. But yes, go ahead.
I am extremely concerned as to the tamper from May 12th with the defendant's tether. But I am also concerned because that is exacerbated by the fact that after the defendant was taken back into custody, he called the victim no less than 8 times to her direct number from his own PIN. I have not had an opportunity to listen to those calls. I did make Mr. Odetella aware of those calls, and I have made a request for those calls to be released to him so that he could hear them. I did receive a note from Ms. Zenda that she had an opportunity to listen to some of those calls. And it is a lot of conversation about the tether, not charging it, not understanding what's going on, and the victim asking why this was happening and why he did this to her. At this point, he was taken into custody after an arraignment, after a bond violation, after he was well aware of the no contact and continued to contact. And I think at this point, his bond currently being set at $5,000 with a 10% privilege is grossly inappropriate.
That's not where it is right now. It's been denied, but yeah, but go ahead. Anything you want to say? But let me just make sure the phone calls occurred after he was brought in for the bond violation. There were more phone calls.
From May 12th at 8:24, May
Got it.
12th at 13:50, May 12th at 13:59, May 12th at 18:45, May 12th at 18:54, May 13th at 15:15, May 14th at 18:17, and May 14th at 19:58. I did not check again after probably about 2 p.m. yesterday, so there could have been more, but as of yesterday at about 2 p.m., that was the last tally that I had.
It does sound impressive, Your Honor, but I have not heard the phone calls or anything of that nature. And until I do, I'm not able to address them at this time. So I would ask for an adjournment on that until we can, until I can hear them and we can address that.
This is his probable cause also today. Emily,
Yes,
this is his probable cause and bond violation.
correct.
Well, during the bond violation as well as the probable cause, May 23rd, 2024, 9 a.m. Bond at this time, given everything that I've seen, his bond is revoked.
Can we revoke his phone privileges as well?
I would state that's premature, Judge, because I haven't heard anything yet, but it's
Really? I know it's up to me, but why would they be premature if they're to the victim's number? regardless of the contact, regardless of the contact.
I leave it to the court, Your Honor. I'm just advocating for the client.
Defendant phone privileges are revoked pending the hearing. Thank you.
Thank you kindly.